All right, y'all. We probably gonna be here for a long time. So if my camera tap out, we gonna keep going. Okay. We gonna keep going. But listen, there are a few things I want to get to when it comes to this case. Y'all know Young Thug is on trial for quite a few crimes at this time. Recently, there was an issue with his defense attorney and the judge that we're about to get into. The judge was caught in a private meeting. I believe they call it an ex parte meeting with the prosecution team himself and a witness that I guess being a problem on the stand. And they pulled him into a private meeting and intimidated him, told him that they could have him locked up for the next 2 years until this trial is over. What is given to me is that y'all plan on this trial lasting for another 2 years. It's giving that y'all are trying to deplete, the funds of Young Thug. And I'm not saying that you shouldn't, because I don't know if this man committed crimes or not. And I hate to say, y'all, I don't care. Like, if he did the crime, do the time, whatever. But what I don't like is the corruptness that's happening in the courtroom, and you feeling like because you're a judge, you get away with the bullshit. So shout out to Brian Steele, I do believe it's his name. That is Young Thug's attorney. And he wanted to front the judge about it. Like, yo, y'all had a meeting. We got here at 9 o'clock. Why am I here at 9 o'clock and y'all still in the meeting? I think they got there a little before 9. Y'all still in the meeting. Y'all didn't come out the meeting till about 11 o'clock or so. And I come to find out that y'all was in there with a witness that had been sworn in. That's a problem. You know what I'm saying? You're not supposed to do that at all. And the judge got so upset, instead of him focusing on the issue at hand where he fucked up, because that was not right, that was unethical, that's not a part of the protocol or whatever. We got to focus on that first before we get here. He didn't want to focus on that first. He wanted to get here and focus on, how did you get this information? You were out of order. How did you get it? Yada, yada, yada. If you don't tell me, he asked the man about 10 times. The man stood on business. I ain't finna tell you shit. He was like, I bet I'm gonna hold you in contempt. Okay, got ready to lock the man up. Locked the man up. The man, or at least he never seen a jail, but he held him in contempt. He was supposed to be arrested, charged, or whatever. And then the guy said, listen, I'm gonna appeal this. And if there is a situation to where you say I can't get a bond, then I would like to be placed in the same jail as my client, because you're already taking away his privileges for me to be able to represent him when I am the lead attorney on this case. So I would like to sit with my client in prison, so that we can work on this case, because it appears that he would have been locked up for 20 days, which would have been like 10 weekends or something like that. He would come in on Friday evenings, get out at some point, I believe on Sunday or Monday. So yeah, he's like, I want to be able to work with my client. I talk to my client like every day. So the judge says, okay, I'll grant that, whatever. All right. As soon as that situation happened, when he was being charged, the wife, because his wife is also an attorney, Brian Steele, she went and hurried up and appealed it. And actually, I had an article where they said that he was good and he was not going to go to jail. So let me share this tab real quick. Okay, bond granted, no jail time this weekend for Young Thug's attorney. Okay, they said the Supreme Court of Georgia granted Brian Steele bond on Wednesday night. He will not have to report this weekend to the Fulton County Jail. They said Steele will also remain free while his contempt of court charge is being appealed. Okay, I'm glad. I'm really glad they did this. It is Father's Day weekend. I'm sure this man is a father, or even has his father or fathers in his life that he would like to damn celebrate. And you was literally finna lock this man up over Father's Day because you didn't get what you wanted, instead of focusing on your unethical, inappropriate, unprofessional ass behavior over there intimidating a witness, sir. And let me tell y'all, ain't nobody finna tell me nothing but prosecutor love, and this motherfucking man definitely is in cahoots. And I'm gonna call a thing, and I'm gonna let people feel how they want to feel. If this was a white judge doing this to black folks, we will be all over this shit. I'm not even gonna hold y'all. Not even gonna hold y'all. But what I will say, and we are over it, we are on it, because we are definitely talking about it. But I feel like the uproar would be much different. But anywho, I feel like this judge is definitely overexerting his motherfucking power. And let me tell y'all something. The way I sat up there and watched how he talked to Steele, that lets me know. And the way he kept glancing over at prosecution, and how the prosecution got her ass up there and trying to support or, you know, help the judge out just a little bit, even though she really confirmed everything still said, is enough for me to know they do this shit all the time. They do this all the time to pull a witness back, to threaten them. I can imagine how many people are locked up in a jail right now after being threatened or intimidated, or really, I can imagine any of the whether they locked up or not, how many witnesses they have threatened or intimidated in this same manner. I feel like it was y'all were too comfortable to do this. Y'all were too comfortable to do something like this. Y'all be in cahoots. And every time I see a judge, I always feel like the judge works for the state. The judge works for prosecution. High key. So I feel like they're going to automatically try to support that side, in my opinion. And you, as the defense attorney, are coming in having to disprove that. Give me a reason to think otherwise. Because right now I'm on their side right out the gate or whatever. But that's a whole nother story, but let's keep going. All right, so he'll remain free. Still is one of two attorneys representing the global superstar. And they're saying the man overseeing Atlanta's trial for the century is determined to find out who disclosed this private conversation to Brian Steele. And Brian Steele said, I can't give you that information. Scoot back. Back up off me, baby, because I cannot give you those details, honey. I can't help you out with that. All right. But let's go ahead and we're going to hop into this one first. Actually, it says on Thursday afternoon, Young Thug's attorney, Brian Steele, made a request telling the state to stop intimidating Kenneth Copeland. And this is like communist Russia, he says. So let's check this out.
I would like the court to look into the appropriateness. Mr. Copeland, to my observations around your courtroom, outside your courtroom on breaks, is surrounded by several members of law enforcement with the district attorney's office and prosecutors, potentially other persons. I don't know why a sitting witness under oath is in a room with prosecutors during breaks, mornings, afternoons. It's totally inappropriate. There are people who are in your court's door. There's a double door where the court sits to its right that aligns with the witness chair. And I noticed people standing there in law enforcement while Mr. Copeland is testifying. He's making eye contact with them. I don't know if they're his brother. My point to you is this: what gives anybody the right to surround a witness? He's not in custody, and bring a witness. I'm sure Mr. Copeland didn't say to the prosecutors, I don't know this, Your Honor, so if you think I'm wrong, then just strike it from your memory. But I'm sure he didn't say, hey, you guys want to hang out in this room a little while? So I believe that he is being led on a tether by the prosecutors, and it is coercion. It is inappropriate. And why would anybody not be recording everything he said? And why do I have to get it in drips and drabs?
Baby.
So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him or the prosecutors think. I don't have any thoughts. So please don't put that in. Please don't put that in in the ether. Okay, but that's what you just said, sir. Ether is okay. Clear. The court wouldn't do it. I wouldn't do it either. So why is it happening? He's a. See, I have no interest other than I'm a referee. Well, you're the referee who spoke with the witness without my presence. Mr. Steele, we're not gonna get into that right now. Well, okay? My point is, how is he being treated here? And why don't I have all this? And why is this going on? What an unfair trial for Mr. Williams. Think about it. If you were accused, Your Honor, and the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is, Your Honor, we're going to object at this. I'm not going to be interrupted. Mr. Steele, I'm not going to be interrupted. But you're, Mr. Steele? Mr. Steele? Yes, sir. What? Okay.
Yes, sir. What?
Making a record for the court to understand. Well, Mr. Steele, I've never been interrupted in a court except for this one. You allow. Well, you know, but the challenges in this point in time is that some of the things that you have said at certain points in time
are not appropriate.
Not true.
Okay, well, that's the court's. The
court is wrong.
Well, you have, everybody has an opinion, and it can certainly be reviewed at the appropriate time. But finish up so you can go ahead and make your record.
Okay, he's being dismissive.
Or anyway, this is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so, well, we don't know that. We don't know whether or not they're true.
What's going on? Every time Mr. Copeland comes in the courtroom or out of court, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a
English judge.
You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said these things. Why?
Okay.
Why do I have to bring it up? You should be bringing it up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial. So I'm moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional response. Remember what I told you about your. And she's going to take me down as opposed to you. So when I start talking, stop talking, please.
A mess. This is a mess. Now, defense attorney Doug Weinstein told Judge Earl Glanville that he has filed a motion to remove him from the case, baby. Okay, are you interested in removing the cloud that's hanging over the case right now? Baby, let's see what this one is about. Okay. Somebody else needs to review that. You shouldn't. He should not get the right to decide whether he is released from a case or not, or from a trial or not. Y'all need to get it somebody else. Oh dang, y'all can't hear? No, y'all can't hear it. Oh, you know what? I know why y'all can't hear it, y'all. I'm sorry. My ass. We're gonna start. My bad.
My attention.
Can y'all hear it now?
Weinstein, you have filed a motion to
I'm sorry, I forgot to switch it.
You have filed an affidavit consistent with that, pursuant to
No, you probably right.
Uniform Superior Court Rule, I believe 25.2.
You probably right,
The
Brittany.
court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit. Baptiste versus the state, I invite you to take a look at that. And that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just.
And this is the part that I was coming in on, saying that I don't think it's fair for him to be able to make the decision on whether or not he's recused or removed from a trial or not. I don't think that should be his decision. I feel like it should go over his head for somebody else to evaluate and make that determination.
Address what you said. I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value. Okay. All right.
Yes.
I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever. Okay. So
See, this is why I can't do with this man here. He likes to play in people's face. You know why they want to recuse you. And you're trying to use this blatant, I guess, statement of if I let you recuse me, then any and everybody will try to recuse me from the situation. And I'm like, that might be what they want to do, but everybody may not have a valid reason. I feel like now they have a reason to, because of the whole meeting that you had.
part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process.
Recuse is like removing yourself, or like excusing myself, removing myself from a situation. I believe that an attorney can also recuse themselves, like if they may have they may be familiar with a defendant, like if prosecution may know the defendant or something like that. I think they can, or have previous history or something, like they can remove themselves basically and allow somebody else to step in and take over.
So I understand what your objection is, or what your statement is in terms of your motion to recuse. I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion. Okay.
Would you grant a certificate of immediate review?
No, sir.
Because
No, sir.
if you grant that certificate, you're
It-
always talking about how the appellate court.
No, because if I grant the certificate, it stops the case. Okay.
I don't agree.
And I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if you
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But
Okay.
aren't you interested in removing the cloud that's hanging over the case right now, Your Honor?
Ooh.
If you grant-
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we have
Not you talking about professional. Not he talking about professional responsibility. When you use your professional responsibility to go and intimidate a damn witness, sir, you are out of order.
An affidavit.
He's a
I would be
manipulator. I can't take him. He's a manipulator. He's a gaslighter. He plays in people's face. It's girl. I would never want to ever be in front of girl. I hate it for all y'all people.
Very careful if I were you, because you have some.
And then you see how he's intimidating this man right now. I'd be very careful if I were you.
Professional responsibility obligations individually and to this court. And so I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to, I've denied the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right.
Oh man. So now I want to get into this other woman, right? This is one of the ladies that came to the front to let me see. Okay, yeah, perfect. Okay. This is the lady that came to the front to have the back of Brian Steele. Let me share that screen so that y'all can see. She came, her name is Ashley Merchant. She's worked with a lot of these cases, I do believe, where attorneys are held in contempt. And so it seemed like she know the law more than a damn judge do. So let's go ahead and get into this.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was he refused to tell, order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know.
Of course,
who it
you're not
was.
gonna ask about what was
Because he's got
said.
too much detail of this particular alleged conversation.
Did y'all hear that? He got too much detail of this particular alleged conversation. No. He got too much detail of this conversation. And you and this woman sitting down here with the short hair, Miss Love or whatever, have confirmed that y'all have had a conversation with the witness. So it's not alleged that the meeting happened. What will be alleged is what was being said in the meeting. Girl, this man, girl, they be trying to, y'all gotta listen to what they be saying, because they be playing on words. They be
for the
some
court to be
liars.
concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
well, no,
notice of that.
criminal contempt is different. It is on the spot.
Oh, damn.
So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says
This is the lady that was grilling Miss Fannie Willis, and Fannie was wearing her out. This is her. Fannie was wearing her out, and I was here for it. But I'm gonna be honest, y'all, I'm here for Miss Merchant in this moment. Now, I may not like all things that Miss Merchant does, okay, but I'm here for her showing up at this point, okay. Now she got stunned. Now it's time for us to see her stun somebody else, because I mean, everybody can have their redeeming moments. So, moment of redemption.
that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Maybe she came with two
Hold on a
cases
second.
for you to look up.
Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've had space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in. Then
You a dog lie. You a dog lie. I don't believe nothing he's talking about. Something. This nigga said you got. I can't. If you're gonna represent him, I'll hear from you. But not everybody else is coming down to speak on his behalf or anything. Because the reason is because it's security purposes. I have to vet. Now, granted, I understand you don't want to hear from 25. It's 25 months in there, but at least two more. Pick your best two.
Go to 8H, and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys, they're all members of the bar. I can give you all their
They
names.
still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box and then there's room in the courtroom. So we would ask that they be
I
allowed to.
don't want them in my jury box, okay?
Oh, y'all, do y'all see this?
I understand.
She has pointed out places
We,
for these.
one
I
additional
can't
attorney
take him. I'm done.
Come in then Alex Susar. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susar. Alex Susar. Thank you, Judge.
Henry Adams, it has two issues. One is the motion for disqualification. Okay. And that's, and I think the judge went ahead and did some other things that caused that.
Yeah.
There to be that
So
issue
you did some
presented.
things too
So
to cause
I
that
don't
to be
think-
a
I'm
thing.
gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna look
Yes.
at the other case just a second.
And there's several others when you're ready.
Hasty's conduct didn't rise to a level in this system warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
What he said?
I distinguish your two. Hasty's conduct didn't rise to a level in this system warrant summary contempt by the court.
It
That's
did not matter. This NIGGA just said that in the previous case that she just mentioned, that situation did not rise, okay, did not rise to the level that it rose here, to the level of contempt here. And the reason why is because he had to keep asking. And it's like, it doesn't matter. The end result, sir, is that they were held in contempt. So she gave you one to relate to, and he tried to wiggle himself out of it. Like he's on some bullshit.
That's the difference with Hasty.
Let me speed him up a little bit though.
Than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
so those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also,
You said 279 Georgia, what, I'm sorry?
Georgia 13,
Georgia 13?
2005 case.
All right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. And there's also a couple other cases on that.
See, but you're all covering under, let me see.
I'm sorry, Judge.
Hold on. The contempt is directed. Trial court has the power after conforting the contempt order to opportunity to speak in his own behalf, announce punishment summarily and without further notice of hearing. I already did that, Mr. Steele. He's already told me, I already gave him the opportunity to do that. So we had that conversation this morning already. So
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And
Sir,
as to how
it's
as
the
to how that
intimidation, sir.
information was disclosed, that's a real problem. That's why it's of such,
I can't.
such an issue for the court at this point in
I
time.
can't.
Judge, and Mr. Steele has a right to make a motion like this. If there were
He does.
He does.
I'm not saying anything, but he
Except for you are.
But he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarty, which I cited to you earlier.
And it is true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise
tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in
So you
contempt.
can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained, not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion
All of this confirms the intimidation he gave to the witness. This is comical.
in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them by nature.
Okay. well,
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the
summarily hold him in
information,
contempt.
but here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay. I said that
You did, but you
one of the
did.
things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't.
Now
believe
you
that
taking
for
it
me.
back. I'm tired. I'm tired. You were so confident. You said that shit earlier. And now you want to say, I mean, one of two ways. You know, I don't believe he did that. I don't do that. Yeah, now because she eating you the fuck up, letting you know how much that's a problem for you to say.
But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms.
But it
Merchant,
don't
I'm of the
matter. You
opinion I'm
shouldn't
gonna
have had a
stand on my
meeting to
ruling at this
begin
point in
with. What
time.
are you talking
I'm going to
about?
hold him in contempt. So
You should not have had no meeting with this sworn in witness to begin with. This is why we're here. And that's what's irritating me the most is that he's looking over this. You need to focus on this before you can get to that.
at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process
You
rights
say
that
that.
Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt.
Ooh.
This needs to be heard by a different judge.
Ooh.
And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
Child, he don't like being signed, baby. Look at this. He
I'll
is
let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal. And
Okay.
we need
well,
to have the order reduced in writing as well.
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case.
he is an ass, baby.
He's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
And you don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you
Oh.
can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is in re
hold on,
recuse.
hold on. The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt. Respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the In re Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeal 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir.
Wow.
In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of
It
law.
is. Give you two cases. One is it's Untema. It's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt, and then there's a Georgia app, I should say, 865, and
so you definitely have the discretion to grant him.
last year.
It says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant a supersedious.
and so you definitely have the discretion to grant him a supersedious bond.
So he
The other
had
issue-
it. So he tried to give them a code, whatever code of ethic, whatever it is, the law of why he does not get a bond, right? He's not supposed to grant him one in this process or whatever, a certain type of bond, whatever. But she's letting him know, to your discretion, you can do that. See, he was doing all that big talk, but didn't want to make note that he can do that at his discretion. And she's letting him know he can, and now he's refusing. And I think that's the main thing she was trying to get on the record too.
Is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
Criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me what the basis of the conversation was. Who I didn't ask what, but he tells me that, then I can certainly he purges himself of the contempt.
Then that's civil.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In re Hughes, which stands for the same point of law. Civil contempt impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today.
Not
Criminal
telling.
contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their
I'm not doing
side of
that.
the story.
I'm
And
not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the
You had
Just
already
what
did
the-
it.
what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person.
And
Because okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you
Oh,
get the
come
bad
on,
side
baby.
of criminal and no bond.
Picking
but
and choosing.
I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out and I'm gonna think about it.
Thank you.
Okay, all right. All right, so we'll be in recess about 5 minutes.
So it's clear that they did all that thinking about it, but know that he came back and told them no, because they had to go to the Georgia Superior Court, I do believe, that it said, who was it that granted it to him? So I don't believe that they did anything. The Georgia Supreme Court were the ones to give him the grant him the bond. So he must have came back and told him no. So they went above his head. Somebody else did it. You know, it is what it is. But listen, we're gonna get into this one, and we're gonna probably hop off this thing. Okay. So let's get into it.
Mr. Steele, I am gonna still hold you in summary criminal contempt.
The judge in Young Thug's RICO trial orders the rapper's attorney to jail for contempt.
How did you get that information
I go to
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I'm not, you should have told me.
Come on.
You got 5 minutes.
This happened after lawyer Brian Steele refused to tell the judge how he found out about a meeting between the judge, the prosecutor, and a state's witness. Steele's lawyer is here with what's next for him and Young Thug's trial. I'm Anjanette Levy, and this is Crime Fix. It was a crazy, wild day in court in Young Thug's trial. On Monday, it started with testimony from Kenneth Copeland, who goes by Little Woody. Copeland wasn't really into testifying, despite being given immunity by the prosecution. He spent the weekend in jail after refusing to testify on Friday. Copeland took the stand on Monday and let it be known that he wasn't going to do it.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Well,
What kind of fucking question is that? Girl, don't nobody in that courtroom want to be there. Why would you even ask him, do you want to be here? Why? Of course he doesn't. Do you want to be here? No, you don't.
you're gonna let me ask you some questions.
Okay.
How old are you?
Grown.
Be
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
why
I
you
plead
look-
the fifth.
Oh Jesus.
So after that, Brian Steele let the court know that he found out that Judge Earl Glanville, prosecutors, and Copeland with his lawyer met in chambers without members of the defense teams, including Steele, present.
Oh,
I was told
Lord.
based upon information and belief that when we arrived at 8:30, 9 o'clock today.
I gotta go back and watch his whole thing
he
now,
did not
y'all.
come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
So can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Now, this seems really unusual that a judge would be meeting in chambers with a state's witness and the prosecutor without a member of the defense team there.
Right.
But Judge Glanville was furious that Steele found out about the meeting in chambers.
So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele.
I know
still
that's
wanna
right.
know,
Everybody should.
How did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why? did
Sir,
this
I'm going to
happen?
hold you in contempt if you don't tell me who.
I would have
I
played the
Tell
fifth
me who
right
this
there.
information
Don't
was
want to
come
be held
from.
in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering. that
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
You
who
don't
you-
have to. I'm
If
gonna
you don't tell me who it is, I'm
If
going
you
to
don't
put
tell
you.
me
I'm
who
going to put
you-
you in contempt
I
because
understand.
that is not attorney-client privilege.
attorney work product privilege. I am not.
How did you get that information
I go to
supposedly
answer that
from my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Glenville actually ordered that Steele be thrown out of court for the day over Steele's objection and the objection of his co-counsel.
Well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point.
Oh
'Cause,
my,
no,
oh
that's
my.
that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong.
Not him
You're
telling him
asking-
he improper.
Listen, I told you the first time, and I'm not
Sir,
going to
I
breach
don't
that
want
confidence.
to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who
cannot
raised it.
you cannot eavesdrop and get
See how he
information
blatantly
that was
accused that man of
not-
eavesdropping?
not meant for you to hear at that particular point in
Don't you-
time.
The prosecutor on the case, Adrian Love, said there was nothing improper.
And I have to pause because he said something at the end that pissed me off. He said it was not for you to hear at that particular point in time. The way that he said it, he uses a very condescending tone. Like his tone be so fucking condescending. And when he said that, he made it sound like we were going to tell you. We were going to tell you. We just weren't going to tell you then. You were going to find this out. Was he really? And then when he did find it out, after I guess maybe y'all had a transcript and some things were given to him, he said when we first started listening to this, that he didn't get the full thing. He was getting bits and pieces of what was said. Clock him.
About what happened with this ex parte meeting in chambers regarding Kenneth Copeland being held in contempt.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Now, it seems like even the prosecutor thought that this could be an issue. Adrian Love asked that Steele be allowed to return to the courtroom.
We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial.
Now, later in the day, and I mean the evening after 7 p.m., attorney Ashley Merchant came to court to represent Brian Steele in this contempt matter.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, and with criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was, because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and
well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
If you're anything like me, you are always cleaning up a mess, especially with pets and kids around the house. So having cleaning products, especially sleek spray bottles like this one, is an absolute.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's just
Crazy
commenced
work, y'all.
this
Crazy
Friday,
work.
June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court.
Now, after the judge said that Brian Steele was going to have to spend his weekends in jail, Steele had just one request.
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay.
And this entire thing has turned Brian Steele into a hero of sorts among defense attorneys. Joining me is Ashley Merchant. She is Brian Steele's lawyer. She's also the president of the Georgia Association of Criminal Defense Lawyers. So Ashley, talk to me a little bit about how you end up at the Fulton County Courthouse last night at 7:30 at night, representing Brian Steele in this issue, this contempt matter.
Definitely not how I imagined my day beginning or ending.
Right.
I was in a meeting and my paralegal came in and said, your phone is lighting up and Brian's in custody. And I said, oh my God, call me on my phone. I'm getting in the car. I'm driving down there. And, you know, I've served for many years as GACTL, as our association's contempt attorney, where we have attorneys that we dispatch if any lawyers are ever held in contempt. We call it strike force. So I'm a member of that. So I'm one of the lawyers that regularly would represent someone. But when I heard Brian was in custody, I had to go myself. And luckily he's very loved in our community. And so many members of our team went down there and were there. And so we had a very strong showing of force, but it was definitely something I did not expect to happen.
You're a criminal defense attorney and you've done a lot of murder trials. Is this unusual? Because it sounds unusual to me that a judge would meet in chambers with a prosecution, you know, the star witness for the prosecution, the star witness's lawyer, and they'd all be there having a confab together without a member of the defense team present. Is that weird? That seems like an ex parte communication or something.
Right. And, you know, during my hearing, the judge is admitting that he had this ex parte communication. And it seems like that should be what everyone's focused on, not whether or not Brian is going to tell him who told him the judge had this ex parte. It just seemed like deflecting. You know, the judge was in trouble, got caught with having this ex parte hearing.
Okay.
Instead of admit to that and handle that, you know, when Brian brought it up, they're going to throw Brian in jail. It didn't make a lot of sense. But like you said, it's unheard of. These proceedings are supposed to be what we call adversary, where all the defense is there. The defendants, the defense lawyers are all supposed to be present. But instead, they chose to have this meeting without inviting any of the defense, without letting them know. And when they brought that up, the lawyer ends up in custody.
The only time I've ever heard of a defense attorney maybe being back in chambers meeting with a judge without the prosecution present or something like that happening is when it was like, oh, judge, we need to talk to you about funds we need allocated for an expert or something like that. If it's like a public defender case or something, you know, that's the only time I've heard of this type of thing happening. But this just sounds hinky. So what are you doing for Brian now? Because Brian, as of right now, is supposed to report to the jail Friday night to spend his weekend in the cell with Young Thug, getting ready for court and doing his time for this contempt that you argued that he shouldn't be serving.
Right. I mean, there's two huge issues there. The first, what we're doing is we are appealing it. So we're filing an emergency appeal. Thank God we have an emergency process in Georgia to appeal contempt orders. We believe the judges of the appellate courts will grant a bond. And so hopefully Brian will not have to spend his weekend in the jail. The worst part, though, is this trial is continuing. And so imagine, you know, we don't just work during the hours you see us in court. When we're in court, we are regularly working after hours, we're working at night, we're working on weekends. I have never tried a case where I didn't work all weekend. And Brian is a very good lawyer and he does a lot of work on his cases. So he's definitely working all weekend. You're taking a man from his office where he has computers, Westlaw, internet, all this stuff, access to the case file. And this case file's huge, and putting him in a jail cell where he's none of that. The trial can't continue. I mean, it boggles my mind that anybody thinks that you could have the lead defense lawyer in custody the entire weekend and this trial continue unhinged. That defies logic to me.
So you're filing the emergency appeal. I mean, I would assume you expect to hear back about that within a day or so. Am I wrong about that? Or what's the process? What's the time frame?
Yes. Luckily in Georgia, when an attorney is subject to incarceration, the appellate courts respond very quickly. And what it's called is a supersedious bond. So essentially they issue a bond that kind of stays everything and says, wait, hold on, we're going to pause this. You're not going to have to go to custody. You get to go and do this appeal. And so it just pauses that while the appeal is pending. If we're successful with the appeal, then Brian never has to go into custody. Obviously, if we lose the appeal, he could still be forced to spend weekends in custody, but that would be down the road. That wouldn't be right now.
But then we have the issue of this big kerfuffle. I mean, this big mess, this big confrontation between the judge who seems very angry and really dug in on his position and Brian Steele, now the trial continues and they have to move forward. Brian Steele moved for a mistrial. That's not happening. Can this trial continue in your view and be tried fairly given what's happened? I mean, it doesn't matter if the jury didn't see this. It's something that is impacting the course of the trial.
I can tell you as a defense lawyer, nothing will affect your advocacy more than a judge saying, if you keep arguing and doing your job, I'm going to lock you up and putting you in handcuffs. Nothing will affect you more. And that's essentially what happened. Brian made an argument. He ended up in handcuffs. He ended up in the Fulton County Jail in the lockup for, an hour or so before the judge let him out. Nothing will stop an advocate in their tracks more than going to jail, because you can't do your job. And, that fear has got to be in the back of everybody's mind in that courtroom, every single defense lawyer. Some of them, they may have kids they've got to go home to, and they can't go to jail. I mean, you think about the things that are going on in their minds. You want to be able to do everything you can for your client, but you can't do that if you're in jail.
But Ashley, can he go to the appellate court? Can Brian Steele maybe go to the appellate court and say, look at what happened? I mean, it's on video. That's not how appellate courts make decisions, but it could be filed as an exhibit and
right.
file something saying this is, some type of an appeal saying what is going on here, what happened is impacting this trial. Can that happen?
Oh, yes, definitely. And I was doing some research this morning working on this appeal,
Mhm.
and the law is really clear. If you have an ex parte communication with a witness during trial, it is reversible error. So this error is, and what that means in the
Girl.
legal world is that's about as bad as it gets. That means it's reversible. That means that any conviction is going to be reversed because of this.
Oh.
So if they want to try and remedy this, they better hurry up and remedy it. And the state should really be thinking about that, because the state's duty is to preserve their conviction. So
Right.
if they were to get a conviction, they have a duty to make sure that the conviction stands on appeal.
Right. Because of the error, it could be reversed. So if they found him guilty, it could be reversed. But even though it's reversed, I believe he could still be tried again. So it's similar to a mistrial, which is crazy to me, because based on this man's error as a judge, it is giving, they are wasting their time with this case. And it should have been a mistrial when everybody was asking that, because as they go forward, if this young man is found guilty, the conviction is going to be reversed. And they have clear grounds as to why, because the judge didn't seem to be 100%. You know what I'm saying? So, girl, this lady right here, y'all, this little court reporter lady be killing me with her facials, bro, looking dead at the camera. But yeah, but also it seems like if he is found innocent, and the defense wants to reverse that, because she said any conviction, so it sounds like they can, but the defense, I'm sorry, not the defense, but the prosecutors will have to put that forth to retry him all over again, possibly, I'm sure more than likely with a different judge. But it's like, y'all wasting time. You come out better filing a mistrial. He's just being so he's so much on a damn power trip. That's really what's going on. And he wants to sock it to people because I'm the person in charge and this and that. And it's like, you wasting your time, you clown. And I pray to God you're an elected judge, so people in that city or in that county can realize to not vote for your ass based on your actions. Because if he'll do this to these people, ain't no telling what he'll do to somebody else. And he's been doing this shit because he feels so comfortable doing it. He didn't even acknowledge his wrong. He wanted to acknowledge who the hell told on him. Like, I can't take it.
This is reversible error. So I don't understand why they're not jumping up and saying, give him these transcripts, give him what he asked for in this ex parte. They have a duty to preserve the record as well. Otherwise, they're just wasting the taxpayers' dollars.
Thank you.
And keeping people incarcerated while they try this case that they know is not going to stand up.
It's not going to go nowhere.
If there is a conviction.
Ashley Merchant, we'll keep an eye on it. Thank you so much.
Thank you.
And that's
shout out to her. I'll be watching these cases like, damn, I should have just went to law school. Okay, I should have just, God damn it. You know? However, I don't want to be in the courtroom defending you motherfuckers. You understand? I couldn't do it. And I damn sure couldn't be no prosecutor. Literally living my life every day to possibly send innocent people home. Now, granted, I'm with you if you know they did the crime, all of that. But then also, like, sometimes I just, I don't want people's life in my hands like that. You know what I'm saying? I couldn't do that. But that's what y'all do, and I hope y'all get paid very well for it. Okay, you probably come out better with the stress they put y'all through being prosecutors. You probably come out better really being a different type of defense attorney, where a person got to retain your services, and then you're gonna get a bigger check out of that than you going in. Girl, let me shut up. Listen, that is all that I got. All right. I thank you guys so much for watching. Okay. Make sure that you are liking up the video. We had over 300 people in the chat, close to 400. So make sure that you guys like up the video, show the support, all that great stuff. Subscribe to the channel if you have yet to do so. We are on our way to what, 75,000 subscribers. Woo. So make sure you're liking up the video, sharing the video, all of that. Okay. Follow me on Instagram and Twitter at JamiThatsMe, and I will catch you guys in the next one. Bye-bye.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. But I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. But drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but you run no corner. Packing the stick with a drummer. When I catch my bad one, king of my city and cul-de-sac. Coming out swinging like